welcome to the Courts and Tribunals panel, everyone. And as co-organizer of this conference, thank you for coming to our conference and making this such a great experience. It's been a really great 3 days. This is essentially the last panel before Justice Karakatsanis comes up, so I feel like we're kind of the warm-up show. But that's okay, we'll make it a good one. And so the way we're going to do this is I'm going to start with my presentation, and then we're going to proceed down the line like this. And there are also two remote presenters, Emily MacLoud and Varsha Aithala. And so we're going to hear from them once we're done with the presenters here. And yeah, I'm just going to leave it to everyone to introduce themselves very briefly. So I'm Suzanne Chiodo. I'm a professor at Osgoode Hall Law School, and I teach in civil procedure, dispute resolution, access to justice, class actions, and all of that stuff. So really, like this panel, I focus on access to justice narrowly defined, right? The old-fashioned definition of access to justice. And so I feel like we're the kind of old and dusty panel in a very kind of vibrant conference, but we're going to do our best to be vibrant as well. Okay, and before
you're not old and dusty.
Okay, I am old and dusty.
No, you're not.
I'm not up with the trends. I'm not a Swiftie. I don't know what TikTok is. I know what it is. I avoid it. Anyway, so before I get started, I just want to acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. And Toronto is now home to many diverse First Nations, Inuit, and Métis peoples. And I acknowledge as well that the court and tribunal system has been, especially the court system, has been very harmful to Indigenous peoples, and we acknowledge that with the presentations that we're giving here. Okay, so we are aiming for 7 minutes per panelist, including the online panelists. So let's see how that works out. So I'm going to start timing myself. Okay, so I'm talking about the role of judges in delays in the courts, and specifically the Ontario Superior Court. And so let's see if this clicker works. Yes, it does. Great. And so, you know, my hypothesis is that judges' perception of their role is a key factor in the delay or expediency of the proceedings before them. And so the literature and the case law reveals kind of two predominating views of the judicial role. There's the more traditional, I guess, passive referee, who tends to allow parties to pursue litigation at their own pace, and is generally reluctant to step in unless egregious behavior has taken place. So it's a bit of a caricature, because obviously there's gradations between these, but that's kind of one end of the spectrum. And then judges who understand themselves to be more managerial see their responsibility as stewarding scarce judicial resources and encouraging efficiency and helping parties move their cases along to ensure, you know, the good stewardship of all resources in the system, so that everyone can have their time in court. And so my hypothesis is that passive referees are going to be more likely to excuse delay without little regard to systemic delay, and then the case managers are much going to be less tolerant of delay in individual cases with a view to reducing delay systemically. And so I'm just going to go through some of my preliminary findings. So I've already touched on the theoretical framing a bit, but essentially courts are places where human beings interact. That sounds kind of obvious, but in terms of how you actually assess how courts work, it's actually really key. You know, judges are not robots who, well, they're not robots now, they might be in the future, who spit out decisions. They're people, and they work in a network of people, you know, court staff, registrars, et cetera, et cetera. And the ways in which people interact are motivated by their goals and motivations and conscious behavior choices about what they think they ought to be doing, right? And so these diverse expectations and experiences all kind of commingle in a sort of legal culture. And legal culture constitutes many things, but in a court, you have sort of a subculture or a mini culture in the court system. And so that's going to affect your view of things, right? So what seems fast to some will seem slow to others, and vice versa. And there's a great study from 1978, which is very old, but not many people have explored this kind of role theory in courts. And it's a fascinating study that contrasts the Detroit and Miami courts, the Miami courts being more case managerial, and the Detroit courts being not. And this really reflects the lawyers' and judges' perceptions of how quickly cases should move along. And so case management, judges who see themselves as more case managerial may even experience what one scholar calls in a 2017 paper, role conflict or ambiguity. Their desire to efficiently case manage cases might conflict with their desire to decide cases on the merits. Should I chuck this case out for delay, or should I let it proceed to a decision on the merits? How others around them perceive their own roles, lawyers and court staff, etc. And the scarcity of support and other infrastructural resources such as scheduling, right? So, I don't want to place all the blame on judges because they're subject to constraints just like everyone else. Okay. And so it doesn't need to be said that case management has received increased emphasis across Canada. I say in the past 15 to 20 years on the slide. Honestly, it's been in the last 30, 40 as well. But despite this trend, managerial judging is still not widespread in practice. So how do we define managerial judging? Well, judges that are more willing to consider the impact of delay, both for the parties and systemically, more willing to sanction parties for non-compliance and other behaviors that cause delay, more willing to provide guidance to parties on how to cure delay, including the setting of timetables, preservation of trial dates, that kind of thing, and more emphasis on efficiency and timeliness. And so, our quantitative findings are in their early stages, very early stages. But, so we're basically looking through the rules of civil procedure as they could possibly touch on delay. So not just dismissals for delay under Rule 24 or administrative dismissals under Rule 48.14, but also other things like extensions of time for service, for expert reports, that kind of thing. And really what we found is that only about 7 to 10% of the sample so far, you could really classify them as case managerial judges. And it's on a fairly superficial kind of look, whether they're willing to set timetables or talk about the need to move the case along, that kind of thing. But it's really only around 10% of the cases that we've come across so far. And there are repeat judges, so it's not 10% of the judges, but it's 10% of the cases where a case managerial judge has kind of popped up and said, we need to move this along. So not many, but again, it's in very early days. And the definition of the interpretations in the case law also tend to promote delay. The definitions of prejudice do not include delay on its own, right? The delay has to have caused something that prejudices the parties to ability to control or pursue its litigation. And also this tendency to want cases to be decided on the merits. So cases are kicked along and along and along, and as long as they're eventually decided on the merits, then that's fine. That seems to be another philosophy that comes out of the case law. And this can also be seen in some of the civil practice directions and judicial education materials that discuss case management, if they discuss case management. Frankly, most of them only discuss case management for complex commercial litigation, class proceedings, and matters proceeding in Toronto and major urban centres. So really the kind of more run-of-the-mill cases that this conference is dealing with, more rural and remote cases, don't get that same case management touch, which arguably they need. Okay, and so what's next? It's coming up to 7 minutes now. So what next? So I'm going to do interviews with some judges, hopefully about 30 of them, about their perceptions of their role. I'm going to continue the quantitative research, and I'm going to try and establish some link between the quantitative research and what individual judges say and how the cases over which they preside proceed. And that's going to be a really tough one, but we're kind of keeping tabs as we go through the case law on the judges that are deciding the cases in the hope of being able to make some link. And I'll finish right there. I'm at 7 minutes 30, so excellent. Thank you very much.
I'm next.
Do you want to sit there? And...
Oh, no,
Okay.
I'll go.
Yes, sorry, you're next.
Okay, I'm next.
These chairs don't move very well. Oh, they're not on rollers, that's why.
Give the clicker, yeah, and perfect, okay. Start that, there we go. Good afternoon. My name's Justice David Brown. I'm a judge of the Court of Appeal for Ontario. I've been a judge for a little over 18 years, 8 years on the trial division here in Toronto, and then the better part of a decade on the Court of Appeal of Ontario. I want to thank the organizers of this forum for including me on the panel. I appreciate this is more an academic, practitioner-oriented conference, so I'm very honored to be invited. In his opening remarks on Wednesday, Dean Farrow asked panelists to keep it short, describe your project. So my comments are going to touch upon what I would call two projects. The first is my outside the courtroom civil process project of the last 15 years. And the other will be a future project that I hope to get off the ground following my departure from the judiciary at the end of this year. So in terms of the last 15 years or so, I have focused outside of the courtroom on writing and speaking about how to improve Ontario's civil adjudication system. That has had two parts. The first was rather basic, proposals about how the current rules of civil process could be better used and applied to provide the public with more timely and cost-effective adjudication of their civil cases. And then the second was more exhortation, I don't know, rocking the boat, whatever you want to call it, urging all interested parties to engage in a radical redesign of our public civil adjudication process. And the second aspect echoes, I think, in some way, the call that Chief Justice Tulloch made in his keynote that opened this forum earlier this week, when he encouraged the reimagining of a more effective and impactful civil process. And so that aspect of my project has essentially been, let's throw the rules of civil procedure in the garbage can and start from square one and really rethink how one should adjudicate civil cases. I've generated a number of papers over the years. They're in an appendix to the paper I submitted to this particular conference. And the one that probably best captures the strategic points I was trying to make was a paper I delivered in 2019. It bears a somewhat Dr. Seussian title, Red Block, Yellow Block, Orange Block, Blue. With so much competition, what do we do? And you can find that paper on my LinkedIn page. My paper for this forum tries to condense and summarize the lessons learned, the strategic points I've voiced over the past 15 years. Simply put, what I've been trying to say is, in a variety of ways, is that a highly effective and accessible civil court needs to learn and then adhere to 5 habits when serving the public, and that's the name of the paper that you have in your materials. And the 5 habits are transparency, perspicacity, creativity, simplicity, and accountability. I discuss them in more detail in my paper. For present purposes, I'm just going to say a few words about each. The first, transparency, 2 simple points. First, courts that profess to be open courts must serve the public with open books. If they don't, they really can't claim to be open courts. And the second is that without public access to court operational data, there is no realistic prospect of improving a particular court's effectiveness or accessibility. Data will disclose where a court's operational problems lie. Data will enable the larger community, such as you folks, to assist courts in fixing their problems. Perspicacity. If perspicacity were to be applied to the issue of court design, at least in the Canadian context that I'm familiar with, it would reveal that most of our courts employ an adjudicative process that is a way to move cases through a system that results in a final determination of legal rights. That process design dates back in this province at least to the 1880s. And while there have been tweaks over the years, in my view, those tweaks have not given us a civil adjudication process appropriate for current times. I tried to illustrate this point in my paper by using 2 pictures of tractors, a machine to which I'm drawn since I own a small farm. The first picture shows a 1923 John Deere Model D tractor, and as you can see, beautifully maintained and painted. It symbolizes our current civil adjudication system in Ontario, an old model to which over the years coats of spanking new paint have been added to keep it presentable, but it remains an old model. By contrast, the current John Deere Model 6135E tractor, and I confess I have 2 John Deere tractors, not only looks different, it provides a radically different level of service, including the latest, for example, in GPS guidance and AI-based crop maintenance process. You open the hood, it's a different machine. Simply put, for many jurisdictions, and perhaps just Ontario, but I think it goes larger than Ontario, to achieve a highly effective and accessible civil court system, they have to trade in their Model D tractor for the new model with its new performance capabilities. Creativity. In my paper, I sketch out ways courts can rediscover their creativity genes by embedding in the process of redesigning their adjudication systems measurable performance standards and bringing in fresh, non-legal eyes to participate. Simplicity, lots of self-reps, need a simple process. Which leads me to the final one, accountability. And here I'd like to outline a future project that I'd like to do when I leave the judiciary at the end of the year. The thesis for the project would be a simple one. At present, Canadian courts lack appropriate institutional mechanisms to hold them accountable to the public. The lack of such mechanisms risks eroding the legitimacy of Canadian courts in the eyes of the public. How to make them more accountable? I see 3 aspects to the project. The first is to develop national standards or categories of data about court operations that would be publicly reported by all Canadian courts. The second would be develop performance standards or goals that an effective and accessible civil adjudication system would be tasked to meet. And the third, and this would be very controversial, would involve thinking about how courts, judges, and court administrators could be held accountable for a court's failure to meet performance standards. And in my paper, I venture some views about how perhaps part of judicial compensation could be tied to whether or not a particular court meets the performance standards set for the court for the year. Whatever the controversy that might have ensued from that, the goal of the project would be a simple one: to enhance the legitimacy of independent courts by improving the effectiveness and accessibility of the services they provide to the public. So that will be my challenge starting next year.
Keep in charge of that, okay?
So I'm John Kahn. I'm a PhD candidate at Osgoode Hall Law School. I'm also a lawyer with a somewhat active civil litigation practice. So that's kind of the ways in which I come to this paper. The title of my paper kind of highlights my original aim, which was to revisit some previous survey work, and also I think the failure, and I want to be candid that I think I largely failed in what I sought out to do. So in 2019, during some earlier research during my LLM, which largely was motivated by a decision of my co-panelist, Justice David Brown, references to him I just checked actually appear in my first sentence, so it's a great honor to speak after him. I did a 7-question survey of all Canadian superior, federal, and appellate courts, and I achieved a decent amount of success, as this slide indicates. A lot of courts actually responded to me, and many courts actually participated in 6 out of 7 questions. And the results, I'm not going to get into them now because I've written about them elsewhere, including my LLM dissertation and my PhD dissertation, and there's links at the bottom there, Deliberate Legal Design. That's where you can find kind of what I've written about. And a general theme kind of emerged from that research, which was, while not heterogeneous, courts are generally very expansive in their views about judicial independence, deliberative secrecy, and judicial confidentiality. But one thing was entirely homogenous, which is courts had really strong views about asking judges if they would ever anonymously track their time. And there's certainly ways of doing that. It's been done in Australia with quite a bit of success. And the general gist of it, which is what Justice Brown talked about in his 2012 decision, is that judges spend a lot of time writing, and in comparison to how long they spend sitting in court, the ratio appears to be somewhat flawed, and we really need to rethink what we're doing in our process. So to paraphrase Justice Brown, courts are willing to open some of their books and to let me poke around and answer 6 questions. So in 2023, I came back to this survey in my PhD work, and I decided to actually survey the 2 user groups of decisions. So the people who write them and the people who are impacted by them, including courts. And when we often talk about the user experience of litigants, I think we often forget the user experience of judges and courts. And that's been a huge central part of my work, because I don't think we can improve access to justice if we don't actually improve the people, and judges have a really hard job actually working within the system. And so I achieved some success. I got 824 people to at least begin my survey, and I got a number of lawyers to take it, and I actually got a number of retired judges to take it, including from all across Canada at all levels of court. But some of the numbers there are kind of curious. I didn't get any lawyers that courts employ. I only got one Canadian court, and I'll touch on that in a moment and kind of the three things I want to talk about today. But really, the key findings were courts' views are probably even more expansive than I think they were in 2019, and that could be because I'm a repeat offender and coming back and saying, I want to see more of your books. I started to think a lot about how universal design for judicial decisions might actually be a bit of a myth, and that was my original aim. And then generally, I think it appears apparent that surveyed respondents across almost all groups and jurisdictions are perhaps not getting a very good user experience once they actually get a decision from a judge or when they interact with courts. So what's my focus for my remaining 4 minutes? So first, courts, what's the reason for their secrecy? Is universal design for decisions maybe a myth? And are decisions in fact too slow, too long, and too complex? So first, looking at courts. 2019, 51% of courts responded to my survey request, and the same was true in 2023. But in 2023, only one court actually participated in the court survey, and no court was willing to transmit my survey to their legal counsel and judges. And for those of you outside of Canada and even inside of Canada, the general convention in Canada when you want to access judges is you approach a Chief Justice and you ask for permission. And if you don't get that permission, you largely shouldn't proceed. And that's always been my approach. In my research, I've accessed judges in different ways, but I wanted to keep with the convention. And at the opening of the conference, I guess it was Wednesday, we heard from Ontario's Chief Justice, and we've heard similar things from other Chief Justices, including the Supreme Court of Canada's Chief Justice. And this paraphrase is mine, but it's close to what we heard, which is user perspectives are paramount. So too is communicating with users. We must collect data to avoid follies. And I don't want to call anyone out, including this province's Chief Justice, or to say that courts are being obtuse, but I increasingly wonder what these statements practically mean. When I contacted the Ontario Court of Appeal and the Ontario Superior Court to generate data about their court, their judges, and their court's lawyers, the very same Chief Justice told me no. Those courts, those judges, and their legal officers simply would not participate. The same was true for almost every Canadian court, except the British Columbia Court of Appeal, who participated in many of the questions, but were also unwilling to forward my survey on to judges and their legal officers. So in reality, many courts talk about transparency, openness, accountability, innovation. My experience has been that most judges actually are simply not interested in proceeding down that road with a researcher like myself. And I think two things are really curious about courts gatekeeping. Almost all the invited retired judges that I asked to participate did the survey and did almost all of it, including judges from all across Canada at all levels of court. And then other judges actually snuck into my lawyer's survey and self-identified as judges and pointed out very candid things that could probably even allow me to self-identify them. Like they were very transparent in their willingness to participate. And I think the last thing that's really curious is I had judges all across Canada pre-test my survey and say, this is really fundamental data, I would entirely proceed. But I never got past the gate. The next thing I think that was really and is quite profound for me to think about, and I think this is something that is important to, I think, all of us looking at access to justice, is we talk and think about a lot about universal design. Can we design an environment or system that works for everybody? And that simply might not be possible in certain venues, especially things like reasons. Reasons serve so many different functions depending on whether you're a reporter, an appellate judge, a litigant, or a lawyer. And the last thing I'll touch on before concluding is this general idea, which I think all of us encounter when we sit down to read a decision. Is it too long? Is it too slow? And it's too complex? And overwhelmingly, the answer appears from lawyers, law students, academics, and litigants. We've got problems. We've got a lot of work to do. And I think that brings me back to my starting point, which is we need to help judges more. We need to help courts more. But courts and judges actually need to let researchers like myself help them. And the last key takeaway, and this comes back to my title, and I talk a lot about this in my research, and I am an empirical legal researcher. I think it's really important, but I overwhelmingly see, and I haven't actually seen this at this conference, so it's great, that people say a lot more than they think they actually know about a subject. When we're doing empirical work and we generate a little bit of data, we need to be really careful and responsible with how we talk about it and what we actually say we think it means. thanks for your time, and thanks for listening, and feel free to check out my website if you're interested in any of the research that I conduct, or if you want to chat further about any of these points. Thanks.
Oops. Okay, here we go. 7 minutes. So today first of all, I'll introduce myself. My name is Carey Majid. I'm the Executive Director of the Newfoundland and Labrador Human Rights Commission. Today I'm going to talk to you about a new conflict resolution service that we offer at the Commission. It's called Community Justice Connect. Oh, you're too fast. That's okay. Community Justice Connect, or CJC, uses restorative justice and anti-racist principles to support people when they look for justice however they define it. And I think that's the focus for us. We work as a team and with community partners, and our goal is transformative justice, not just what we call at the Commission, the sausage factory of human rights complaints processes. And referencing back to your photos, I get the point that you're trying to make, but to me, that tractor looks the same. So that's what we're trying to, it might be souped up, but it's still green and yellow. So here we go. I'm not an academic or a researcher. I kind of feel out of place on this panel, but I've been practicing law for a really long time. I feel like it's a privilege to be in this profession. Unfortunately, if we don't find new ways to resolve conflict and achieve justice for people, we risk losing, we risk losing legitimacy with the public that we serve. Conflict is normal. It has the potential to make real change. When people are in conflict, they say they want justice, but what does that even mean? Who gets to define it? For us at the Commission, it's what the Human Rights Act says, and it's litigation, essentially. And we know that this doesn't help with understanding, healing, or what happens to people after the fighting is over. These systems just don't work for people. They cause harm and re-traumatize those involved. At the Human Rights Commission, I see people at the beginning and at the end. They don't want to be there if they come at all. They're isolated, exhausted, and frustrated. And this is not about our staff, our intention, or our ability to do good work. This is about a bad process and a lack of institutional trust. I don't know why it keeps flipping. Anyway, I'm up to this one, so I'll move forward.
You can use these buttons if you want to.
No, then I'll be stretched all over here. Don't put that in my time of 7 minutes. Okay, so what does it,
Don't just tell me and I can.
yeah, no, it's fine. So what does it mean to imagine a different way of human rights justice? I'm sure there's lots of people in this room or at this conference who have dreamt of a different way of doing things. You work in a process and you're like, man, that would work way better if we did this. And it doesn't, if you try to implement change, it doesn't always go the way that you want it to work. For us, it certainly has not. We've had lots of conversations, and we know that this is a work in progress, but we're building and learning as we go. So we take a restorative justice approach to everything we do. It centers relationships and community. It asks different questions and talks to different people. Every process is different. That's, I think, key. It's not perfect and it takes time, but it lessens trauma and heals, or tries to heal. Restorative justice is not an add-on or a diversionary process. It is not about having the same conversation, just putting people in a circle. I see it as a philosophy or a way of being. It is foundational, a root system. Now it's moving on its own. It did. I'm not even touching it. And based on the understanding that we are all worthy and interconnected. As a lawyer, obviously my first instinct when we started thinking about a different way of doing it was to create a community type legal clinic. I've heard some great examples of clinics like that here at this conference. But living on an island in the middle of the North Atlantic has some advantages. We're small and the people already understand the importance of community and relationship. Our office is also small. We're part of the Department of Justice and Public Safety, but they don't know we exist. So we kind of are left alone. Don't tell anybody, but we're left alone to kind of come up with some new creative things. So Community Justice Connect approaches conflict and racial harm in a different way. We try to create space to talk about discrimination in a way that people can hear it, And that doesn't mean watering down the conversation. It just means that sometimes it takes people time to get to that table to talk in a healthy way. We invest time to build trust at the front end, which is at the heart of the program. We consider the safety of the people, well-being, and possibilities. We understand that the person sometimes knows best about what they need, and the Human Rights Act is not a solution to some of their problems. We've learned some things, though. We've asked ourselves some hard questions about the model, how we train people, our participants, and possible outcomes. And we've listened to feedback from community people and tried to make changes to reflect that. Relational work needs to be built into our organization's way of operating. So everything we've learned from Community Justice Connect and from community partners, we're now trying to transition it over to the human rights complaints process because we're all connected. Our biggest hurdle so far, lawyers. We're the worst. And I can say that because I am one of them. But that has been a real stumbling block because people don't always understand what we're trying to do. And it's really hard to get it down into the little kind of elevator pitch so they get it. Engaging respondents. We don't call them respondents, but that's what they are, and I guess for ease. For them, accountability doesn't mean huge cost, punishment, or shame, but that's what they think because that's how our current process punishes people. So trying to get them to the table, trying to understand the value in what we're trying to do, they lawyer up and the conversations kind of, so that takes a lot of time. And really just the tension of building a restorative justice program within kind of a human rights process that's got statutorily required timelines, filing deadlines, et cetera, has been difficult, but we're learning. So, people are sick of all the shenanigans. They don't see it as worthwhile. It's an endurance game. They don't want to testify or be cross-examined. They just don't want this process. So throughout this presentation, I've used images of the natural world as a nod of the intelligence of organisms to change and adapt. And I think we as a people who work in the justice system need to do this as well. I'm going to skip through some of these. I guess really the only thing here I'd say is we work as a team. We're trying to get a social worker on our team. We have non-lawyers, and they're the ones that take the lead in the process, and we kind of step in and out and answer discrete legal issues as they come up. So I'm gonna just skip right to the end. And basically, I come to this work because I believe in the humanity of people, community, and the power of relationship. But I've often thought, is the Human Rights Commission a place for me? Do we actually promote and protect fundamental human rights, or is the legal system doing exactly what it was designed to do? We often hear the term do no harm. Are we doing harm when we think we're not? I guess what we've done and what we've learned is we've made a lot of mistakes. We're trying to change, and we understand that it's a work in progress. And hopefully the human rights complaints process in our province will look different in a number of years as I approach retirement and no longer will be working there. And I think because of that, and because of the people that I work with, Kevin O'Shea here at the back from Public Legal Information of Newfoundland and Labrador, I think I can keep doing this. After all, justice to me should be a healing ground, not a battleground. Thank you.
Am I up? Yes, you are. Oh, okay, all right.
Watch out for that clicker, it's really slippery.
I gave you extra time.
Thank you.
All right, thanks very much. My name is Noel Semple. I'm from the University of Windsor Faculty of Law. And I'm here today to talk about tribunals. I had another title. The real title is The Good, the Bad, and the Ugly of Tribunals from an Access to Justice point of view. I'll just say to begin that when I'm talking about tribunals, because this is an international audience, I'm talking about what we call Commonwealth-style tribunals, so the type that exist in Canada, Australia, New Zealand, England to some extent, although they've moved away from the model a little bit. So tribunals on this kind of Commonwealth model are court-like entities in the sense that they are dedicated to resolving disputes by applying the law, but they are different from courts in several key ways. First of all, they're specialized. Tribunals deal with only specific types of disputes. Secondly, there is a sense of teamwork with tribunals. So the trial judge in our court system is sort of a solitary, heroic figure who has a lot of authority and expectation to resolve a dispute by themselves. In tribunals, we see, for example, panels, often interdisciplinary panels involving non-lawyers resolving disputes at first instance, and more of a sense that a tribunal has an institutional responsibility for resolving cases as opposed to the individual judge. Okay, so the good, the bad, the ugly. So we've got, this is just a few of our many, many tribunals we have in Canada, but with the 7-minute version, I don't have time to talk about a lot of these. Okay, so the good of tribunals from an access to justice point of view is that they have a demonstrated ability to produce fast, accurate, substantively just dispute resolution. So the Social Security Tribunal in Canada is often considered an example. The Social Security Tribunal lets a self-represented litigant sue the federal government and get an authoritative adjudication of that dispute within about 4 or 5 months. And the process is one in which the tribunal itself provides, in-person live help to the person who's doing it. There's an opportunity to mediate. There's a lot of reason to believe that the decisions that come out of the Social Security Tribunal are substantively accurate and just. And it's just a dramatic contrast from what it's like to sue anyone in just about any of our civil courts in Canada, where it's more like 4 years than 4 months, and self-reps are completely they're in a very difficult position in our courts. Now, of course, the obvious response to that is, yeah, but the Social Security Tribunal deals with relatively simple, straightforward disputes, whereas courts have broader jurisdiction and more complex disputes coming to them, and that's true. But the burden of my argument is that there are distinct characteristics of our tribunals that make them superior for the resolution of certain types of disputes, and that there's a better way for us to make use of those attributes. So tribunals are designable. They can be designed according to the principles of person-centered justice, whereas courts respect precedent and common law and procedural fairness and all those things, and cannot really be designed by anyone outside themselves because of the principles of judicial independence. We've been talking a lot about accountability in John's work and Justice Brown's work in particular. Tribunals can be designed to be accountable. The legislature can create a statute that says these tribunals report this type of data, and the individual adjudicators are responsible to the chairs and so on. Again, that can't really be done with courts because of judicial independence, which is a very important thing, but it's a key distinction. Okay, so much for the good. The bad of tribunals. So they're prone to judicialization. They're prone to become, for their distinctness to erode and for them to become more court-like. There's a lot of confusion about the role of tribunals. So we have this Supreme Court of Canada decision from 2003, Oceanport, that says that the purpose of tribunals is to implement government policy, which is quite problematic if you start from the point of view that their real work is to resolve disputes in a highly accessible way. And there's a lot of confusion about whether these are agents of policy and agents of democracy as opposed to agents of justice. I think they have to be agents of justice. The ugly, tribunals are prone to just collapse. And this is what happened in Ontario after 2018, basically because the government decided that all of the adjudicators in tribunals who'd been appointed by previous governments had to go. So there was a purge, and their ability to work pretty much collapsed quite quickly. So I was asked to finish, to be the last panelist because I'm allegedly optimistic. And here is my optimism. I believe there is a path whereby tribunals can revitalize civil justice in Canada. That's kind of an old idea, like legislatures have been creating tribunals for 150 years because they're supposed to be more accessible than courts. But I think we need to come back to it, and we need to focus more on how that optimism and that potential might actually be realized. The number one step on that path, to me, is create a system of depoliticized and professionalized appointments for tribunals. We need to get rid of the idea of implementing policy and being accountable to changing governments, and we need to understand this as important work that needs to continue in a consistent way, notwithstanding changes in government. I think legislation is the way to do that. Number two, we need to better understand the best practices of the best performing tribunals in Canada. And we need to spread those best practices among the rest of them, because there's a large degree of variability in terms of how well these tribunals are functioning. Number three, I think we still have unexplored potential to use tribunals to relieve the pressure on courts. I think there's lots of things which are within courts' function, for which we should explore tribunal alternatives. Family law is a big one that comes up again and again. And with the level of crisis we're at in terms of the inaccessibility of civil justice, I think we've got terrific ideas about how we can revitalize the courts from within, but I think we also need to explore this parallel system and its potential to enhance access to justice in our country. Thanks very much.
Thanks, everyone. So Noel, I actually misspoke when I said you were the last presenter. Of course, now we have our online presenters. So we're going to go to Varsha Aithala first. And Varsha, I'm going to ask you to introduce yourself and then proceed with your presentation. Thank you so much.
Thank you. Would you be sharing my slides while I'm speaking, or should I manage my slides?
If you could manage your slides, you have the capacity to share, so perhaps you'd like to share them.
Yeah, let me do that. Are you able to see my screen? Wait, now?
Hang on, it's coming. Here it is, yeah. Thank you.
Okay. Give me a second. Yeah. Okay. Great. Yeah. Hello. I hope my time didn't start running. I'm Varsha. I'm a PhD scholar and an assistant professor based out of the National Law School in India. I'm sure that a lot of what I'm going to speak about, while its specific focus is on India, might be something of interest to the international audience around the table and at the conference itself. So I won't waste too much time because I want to discuss a specific aspect of the broader question on access to courts as an aspect of access to justice. And there I want to highlight a specific focus on funding of courts, which I understand is an extremely sensitive topic across jurisdictions. But my focus has been on India, and I hope to use that because it's also a Commonwealth country, to use that to hopefully inform discussions at the conference itself. A lot of what I'm saying here is common knowledge. So let me go to what I am understanding as court infrastructure. I'm defining this. So I'm conscious that there's a lot of literature on court design, court architecture, access to courts, and some of the speakers before me have also spoken about the principles of what a good court should be doing. But what I'm hoping to achieve through this discussion is a broader understanding of court infrastructure, where I'm talking of not just the physical elements of the court, which is the spatial and design elements. There's also an administration element, which some of the speakers before me alluded to, which is a personnel management and information management. And the third aspect, which is the technology of the court itself, which refers to data and how courts manage information online and physical and in physical formats. So the definition itself is really broad. And in my paper, which is very, very long, I've tried to, and I don't know if it's shared already, maybe not, but I will share it if anybody's interested in reading it. I discussed when I go through an empirical analysis of the status of, and that's going to be my next slide, the status of how courts are working in India, the court infrastructure working in India. And I've spotted some of these issues, which I'll be bold and say are not limited to an Indian court, a court in India. I think they probably apply to courts across other jurisdictions as well. And what then I shift the focus to financing courts, funding of courts. And just for context, in India, courts are funded using tax revenues. So they're public. It's a public good, access to courts. However, through the empirical analysis of budgets across about 2 decades, I've been able to point to specific issues with um, the way that the money has been utilized. Uh, One, definitely the lack of information on where the money is coming from. While we all know generally that taxpayers fund courts, but we don't really know what are the various mechanisms through which the funds flow. So I try to trace that in my paper. Um, the lack of transparency, which was already spoken about, in how the money, that pot of money is then allocated for the various functions of courts. In my case, specifically the infrastructure of courts. Uh, probably a peculiar feature of the Indian courts is the idea of a lot of the money being a lot of reliance on what are government schemes, central government schemes. Again, India is divided into a central government like a federal system similar to Canada, where there's a central government and there are states at the regional level where there is a high dependency on the central government schemes for funding of courts. And a lack of accountability. Therefore, there is requirement to talk more about where the money is coming from, how it is used, and what we can do to supplement uh, running of port infrastructure. Um, there is more importantly the question of a sustainable basis for funding because tax revenues are not sufficient. And that's come out of an empirical study that I've done in support of this discussion. So there is one option that I'm considering, and I'm very curious to understand what people think about this. There may be different formats of this, but broad structure is this, and I'm just going to finish off with this. The structure is that there is in India a mandate on companies to provide some of their money for corporate social responsibility projects. I'm suggesting that because of the broad public purpose of corporate social responsibility, uh, uh, some of the money from corporate social responsibility projects to be moved specifically for port infrastructure to be managed not by the system itself, not by the judiciary, but by an independent judicial infrastructure council, a council which is set up specifically for managing port infrastructure. I understand that there are self-governing judicial councils which are existing in several parts of Europe, for instance, and there are issues with that as well. However, in order to basically deal with the issue of governance and accountability of these councils, we could be using smart contracts backed by using blockchain technology, where there is an independent bidding process for the project. Service providers which are expected to provide infrastructure projects are then able to bid competitively, and then the funds get automatically released from the fund into the service providers based on performance. So performance becomes the key. And then there is a clear way to measure the impact of the utilization of the fund and the deliverables as well. Why am I saying all this? Is this really feasible? It builds in what I think is as an internal accountability within the system. Corporations which are accountable at the board level, at the committees, internal corporate social responsibility committee levels. There is the government overview over companies' corporate social responsibility funds, which all happens at the external level within the court infrastructure itself. The infrastructure council, because it's set up as a fund, is monitored by its investment committee, its advisory committee. Courts definitely are interested in managing their infrastructure projects. Therefore, the court registry, which is the administrative side of the court, is interested in ensuring that the infrastructure service providers perform. Service providers are therefore also responsible by contracts, smart contracts, which ensure that the projects are completed in time. So this is a dream of ensuring that a specific idea of accountability within court infrastructure can be a self-sustaining model. Very happy to hear your thoughts. Thank you.
Thank you so much, Varsha. And now we're going to move on to Emily, our other remote presenter.
Hi, everyone. Good morning. Thank you so much for the opportunity to present. I am coming to you from the lands of the Gadigal people in Sydney, Australia, and I'd like to acknowledge traditional custodians of land throughout Australia and in Canada as well, where this is taking place. So today, I'll be discussing a framework that seeks to serve as a bit of a guide for designing technologies in judicial settings. I'm a design strategist at Portable, which is a human-centered research, design and development agency based in Australia, and we work across several impact areas. One of them is justice. A number of the examples that I'm going to be sharing today are based on the work we do with our clients, designing and innovating court and judicial process. But this is very much a collaborative piece, and my colleague Joaquin, who's at the Metaverse Lab at Johannes Kepler University in Austria, conducted research on the Chilean judiciary's use of the social media platform Facebook. And in discussions with him about what we've both seen, this framework was born. So the 5Es framework seeks to offer a holistic perspective, catering to designers, legal professionals, and policymakers navigating that complex landscape of digitizing judicial process and advancing access to justice. And Justice Brown, I very much feel like the 5 habits are complementary to the work that we've done. So it's no surprise, we all know that digital transformation in the justice sector is quite complex. COVID certainly sped things up, and in its aftermath, we're reflecting on what's worked and what maybe hasn't worked so well. We're going to look at a range of examples used by the courts and the judiciary, and this contribution seeks to be twofold. So the first is that it's a framework that's grounded in diverse and contemporary literature and provides new perspectives and concepts to enrich this discussion. But on a very practical level, we're hoping that fellow designers and legal professionals and policymakers will find in the framework guiding elements that will help them when they're undertaking projects that will involve the digitization of judicial process. But first, the application of this is very important. And we just want to highlight that by no means we consider this to be linear. Rather, it's a bit of a palette, if you will, that combines various elements with certain colors dominating at certain times. So the elements of the 5Es framework starts with experimentation. And this highlights the importance of learning through lots and lots of testing. Here we want to stress that experimentation needs to take place in controlled environments to assess feasibility and impact before widespread adoption. And we also want to stress that the question is not just, does it work? Instead, the question might look like, what is this prototype revealing about the reality in courts that we did not know about before? What is the dark matter that's been revealed through this new way of working? The Chilean example is really important to highlight here. So back in 2012, the Chilean judiciary started their social media activity as part of a bigger communication strategy. And the first social media platform that they had an active presence on was Facebook, but then others joined, such as Twitter and Instagram. But as the platforms evolved and offered new features, functions, and use cases, the possibilities for the judiciary to engage with citizens also increased. So from the traditional posting to answer inquiries of citizens via the chat function, to live stream court hearings and having judges then host open sessions on Facebook Live, it expanded considerably. And this can be neatly contrasted with Amica, which is an Australian AI-powered platform designed to help separating couples. And it was a project that we were involved in, and we still are, with the Legal Service Commission of South Australia. And the process taken was very intentional and iterative. It involved a number of engagements with real people to ensure that the solution was user-friendly and addressed those real-world challenges that we were seeing. So while the Chilean courts repurposed a commercial platform, Amica was purpose-built, and the contrast eliminates the different approaches to experimentation. The second pillar, exacerbation, refers to the risks of amplifying existing biases or creating new ones when repurposing applications. And what we have seen recently, when not designed carefully for the judicial context, AI systems can actually worsen existing exclusions and injustices. So, for example, using Facebook's algorithm to stream court hearings in Chile may inadvertently lead to outcomes like the viral dissemination of courtroom proceedings. And this raises questions about the appropriateness of using these commercial technologies in judicial settings. In contrast, the development of Amica involved the careful control over its data inputs to avoid bias from historical cases. The third pillar is ethics. And we know that technology is not neutral. And while the law is the outcome of democratic process, the regulation that comes into play with technology is certainly not. In designing for access to law, multiple approaches to ethics can be considered, from traditional approaches such as consequentialism or utilitarianism to more novel and refreshing approaches such as care ethics. And value-sensitive design is an interesting one to explore here. It's a proactive approach to incorporating values into the design process and is sometimes described as a way to front-load ethics. Consider video conferencing technology that's been designed to support digital-first court hearings. If, during the design process, the design value of usability, say, is favoured over the judicial value of impartiality, this might lead to a situation where the judge appears on the computer screen just like everyone else in attendance. And what implications will this have on the appearance of the independence of the judicial bench? By being explicit about the values that drive the design process, we can create ways to manage trade-offs. And this is something that we do in the work at Portable, and recently working with the Coroner's Court of New South Wales, working with them to design a solution to inform loved ones about where the situation is at. We developed a set of grief-informed design principles, thereby making explicit what should be prioritised in future work.
Emily, I'm sorry to interrupt you mid-flow. You're over time, so perhaps you could just wrap up in the next minute or so.
Sorry, I just got into it. Everyone's been so on time too. So there's always one. Evaluation is that fourth pillar. And empowerment is then the last pillar. And it's, I think, just kind of to wrap up here, what's been really, really interesting is just sort of contrasting the various examples around the world where people are using technology in different ways. So thank you.
Thank you very much. Okay, thank you, everyone. We're doing very well for time. We've got, on the assumption that we started quarter of an hour late, therefore we're ending quarter of an hour later at 12:30. We have half an hour for questions. My assumption may be wrong. So this morning has been a little bit chaotic. So if it's wrong, we might get cut off at 12:15. But otherwise, we have half an hour for questions. And so if you could just come to the mic at the front if you have a question, and don't all rush at once. I also have a couple of questions online that I can start with if that's preferable. So David seems to have something.
Thanks. Sorry. Thank you. Really interesting, all the presentations. I just want to throw out a couple of questions. One to Carey. I was hoping you could describe a little bit more what the Community Justice Connect is, because I didn't quite catch sort of, you said it involves non-lawyers and so that's one question, and then I'll do the other one and then sit down.
That got cut out of my presentation.
Okay. Justice Brown, all the work that you've been doing in advocating for open courts is super important, and thank you for that. Why do you think you're going to be any more successful once you're out of the court system and trying to do this than within it? I mean, is being in the court system the problem? So just sort of, what's the barrier here?
Carey, would you like Sure. So, yeah, as I said, it got cut out last night when I was going through these notes. But essentially, it is what it is. It's like people come, they either come through the traditional human rights complaint process or they connect with our office in different ways. And we talk to people and we talk to them about how they define justice, what they're looking out of this kind of concept of conflict resolution. Sometimes it's very clearly within our jurisdiction at the human rights complaint process, but people don't want to go through that route. So we have restorative justice practitioners, we have a community kind of activist and anti-racism educator, we have lawyers on staff, we have a mediator on staff, we have intake people, and we kind of work together as a team to, in that, the most of the work in the manual that they've developed is at the first conversation. Not just like how lawyers approach it, what happened then what happened next, and then what happened next. It's like, what do those people need to achieve justice? And that can take some time. Then it's engaging with the other side, but maybe it's not. Maybe it's connecting them to different groups or different people, or we had one where there was an incident of racism out on the street and that person didn't want to go to the police. So instead they connected with a local group, because in Newfoundland and Labrador, it's pretty small, but we knew them. And they connected them with the local anti-racism coalition just to chat. And that was enough for that person. We've worked with other organizations. There was a case that did come through our complaints process, anti-Black racism in a volunteer kind of sports organization. It came in as a complaint. We tried to mediate it. Instead, they chose to go a different route through Community Justice Connect. So all of that litigation stuff just went to the side. And our restorative justice facilitators and community facilitators worked with the organizations talking about how to listen to Black people talk about racism. So those white people in the organization didn't just sit there and say, but I never saw anything, that never happened, we're not racist. So like learning how to have those difficult conversations took a long time. But that organization bought into it. They saw it as an opportunity to change their organization, how they train their boards, what policies they implement. And the guy, he basically said, I just want to play this sport, right? And so I worked with them. They were developing different, say, policies on transgender kids. So nothing to do with the original complaint, but we've now made that connection, and I'm working with their board to try and develop these policies. So it can be really whatever it needs to be. And so that doesn't always work for lawyers because we need rules and procedures. And we did do a manual to kind of put a framework around it, but it really depends on what that person needs. And 99% of the time, it does not involve any sort of just like traditional justice process. I don't know if that answers your question.
And thank you. And Justice Brown? Maybe we should ask you this question after December.
No, I've said what I've wanted to say all along, so I'm not going to change now. It's a very good question. I don't know. Perhaps it'll all fall flat on the face, but there might be certain opportunities that are not available to a sitting judge. The judicial culture is very hierarchical, and it's in our ethical principles. There's sort of this notion that outward-facing communication by the courts really lies in the province of the administrative judges, whatever they may be in the various jurisdictions, and that if you're not part of the outward-facing part of the hierarchy, then you just deal with your cases and you put the nose to the grindstone and you really aren't supposed to rock the boat. Some judges view that as not an appropriate distinction and are of the view that all judges owe a duty to the public to ensure that they get the best of service that the system's capable of, and that they advocate to that end on behalf of the public. And in fairness to the ethical principles, there's a recognition, at least at a theoretical level, that is available for all judges. But the judicial work environment is a highly controlled environment in terms of assignment of work and that sort of thing. So there are internal pressures. I mean, of course there are internal pressures. And I think there's a decision on the individual judge. Do you succumb to those pressures or do you ignore them and do something else? Most judges succumb to the pressures, others don't, and you get dinged for it. But I think leaving the judicial environment, the upside is one is free of that kind of pressure, and also one has greater liberty to really step outside the work that the taxpayers pay us to do, which is the adjudication of specific cases, and spend time on non-adjudicative matters, which in this particular case would involve a lot of liaising and assembling of the appropriate skill sets from various sectors in order to be able to do the project that I would like to do. And that is a practical matter of employment terms. It is something difficult for a sitting judge to do because we're paid to decide cases, not to do projects like that. So there's that sort of liberty. The flip side is, if it's difficult to get data about court performance from inside the system, how is it going to be any easier to get data from outside the court system? And I guess my candid view would be the goal of the project that I have in mind would be to encourage courts that it's in the best interest of the public that they serve to disclose more information, and that as a non-sitting judge, one would have greater ability to have recourse to channels of public communication that would be able to present things. And what I'm thinking of tangibly is there are a number of aspects to accountability, but I see bringing together people in a few conferences, trying to identify through those who've got expertise with proper reporting statistics for business, for private and public sector things, to come up with the kind of data set that all courts should publish that would be of use to people, many people in this room, because I'm firmly of the view that the more data out there, sure, some of the problems are going to look really bad right now, but once you know the real extent of the problems, you can work on the solutions. It's night follows day. So a few conferences to do that, and then the same on performance standards for courts. I come from a public utilities regulatory practice background when I was in private practice, and the quality of service given by public utilities is often measured by certain performance standards, and I have at a theoretical level at least a notion one could develop certain things for courts. And simply, I mean, the Supreme Court of Canada, for example, has the best set of statistics out there on what I think is one of the most important statistics, that is, what's the lapse of time between the time a case hits the court in first instance and the time there's a disposition of the case. And you take a look at the annual report of the Supreme Court of Canada, and you can add up two numbers and you can arrive at that. It's the only, Nova Scotia Court of Appeal also allows that. But those are sort of the statistical categories. So I think there would be access to more flexibility to access a greater skill set in the public, and also to access public channels of communication to perhaps convey the message that more disclosure and performance standards is a win-win for all of us, even though there may be a bit of, are we really looking that bad in the first part? Now, that may all be pie in the sky, but I'll pursue it for a while.
Thank you, Justice Brown. I think where we are right now, you're going to have to prize the data from the Superior Court's cold, dead hands. But yes, we'll take the next question.
Thank you.
Yeah.
Ricardo from Chile, just two quick questions. First one is for you, Suzanne, is whether you are controlling for complexity of civil cases, on if this affects, for example, the attitude of a more passive or a more managerial judge, and how you are controlling if so. And my second question is for Noel. I'm a huge fan, but a huge fan of the Civil Resolution Tribunal in British Columbia. I mean, the way they use technology is a really good example on how to use technology to provide and improve access to justice for less complex but very frequent justiciable problems from regular people. So, for example, the way they collect and publish data on procedural justice, how people perceive the legal procedure. So do you think there is whether there is room for learn the kind of tools that they are using to, for example, improve regular courts here in Canada?
Thank you. And sorry, what's your name? Ricardo. Okay. Hi. Okay, great. Yeah, so we're collecting data on the complexity of cases, but we haven't figured out a way to control for that yet. So that's the simple answer. And Noel?
Yeah, so the Civil Resolution Tribunal is definitely a model in a lot of respects. It's completely online, 99% online, and that's, as you mentioned. And it also, as you mentioned, reports data, and that accountability, that's kind of been a theme here, is really a model in a lot of ways. The other thing that's really interesting about the BC CRT is they have this 4-stage process where they're always trying to resolve disputes in line with the law. But they start off by informing people, now you've got this information about your condo or whatever, can you hash out yourselves? And then they mediate, and then they adjudicate, and they have a workflow which is very much data-driven and people-centered and based on an understanding of how these disputes actually exist in people's lives, and creating the maximum opportunity to resolve them as justly as possible, as quickly as possible. The challenge for the CRT is that it started off very specialized, focused on condo disputes, a couple other things, but as a reward for its success, it's been given more and more things to do by the BC government. And now it's adjudicating disputes about motor vehicle accidents, in which, you've got a state-owned insurance company, the Insurance Company of BC, and people are suing it for benefits. And the government has an interest in keeping down the payouts the ICBC makes, so they don't have to raise premiums. So questions have been raised about now that the state is basically a party before the BC Civil Resolution Tribunal, and yet the state also has a lot of discretion to appoint people with minimal terms and no judicial security. Questions have been raised. So it's a really interesting one to watch for sure.
Yeah, I really hope it doesn't become a victim of its own success, because I too am a fan, and I know Justice Brown is. So, okay, so there's a couple of questions online. One is for you, Noel. What are your reasons for thinking that the Social Security decisions are fair and substantively just? You referred to the Social Security Tribunal. Maybe substantively just is a bit unfair, but you've referred to the SST as a kind of a model. So maybe just to frame that question a bit differently, why is that a model as compared to other tribunals?
Yeah, so we don't have great data, and perhaps I overstated the point when I said they have a good reputation for substantive justice. The data we have suggests they're very seldom overturned on judicial review or through appeal. That's basically all the data we have. But of course, there's different reasons why people don't seek judicial review, so perhaps I should temper that. Maybe I could say there's no reason to believe that it does a worse job than other courts, than courts do when it comes to, and when I say substantive justice, I just mean like identifying the correct law, finding the facts, applying the law to the facts. So I don't see any reason to believe that they're doing a worse job of that, and appeals and judicial reviews would not suggest that there is a problem that I'm aware of.
I think they've also, they did a plain language rewrite of their rules as well.
Yes.
And I think their electronic processes are pretty good, but I don't know so much about the second one. So the other question online was, is delay itself a way of managing caseload by deterrence? Yes. It's not the kind of deterrence I don't think any organization that calls itself a justice organization wants, right? So delay is deterring, can potentially deter people from filing cases, but then you're deterring the people with less money and less time and all of that stuff. So it's really not a substantially just form of deterrence. And it's certainly not, we're so bad that we don't have an overwhelming caseload because we're so bad nobody wants to come to us. I don't think any organization wants to be able to say that. So,
also, I think the point has to, I know we're talking about a whole range of different sorts of disputes that are being adjudicated in different forms, and there's no uniformity to the disputes. But the civil courts, by and large, spend a lot of time on money disputes, and the importance of the timely adjudication of money disputes to the overall health of an economy has been, I think, demonstrated through historical review, economist review. So delay in the courts on those sorts of disputes, and also the recompense for personal injury and whatnot, but it will simply smother the economy. And once that happens, you've got capital leaving a country, and whatever one's ideology, at some point in time, you need money to create wealth and at least sustain the level of living that we're accustomed to. So delay in that sense, I can have a specific memory of one particular case, $40,000, 3 invoice, physiotherapist charged a client stiffed him, comes to court, we have a trial of all things for $40,000 at the end of the day. But for him, $40,000 was a big ticket item for his particular business. And he employed a few people, and so the health of the economy depends upon, in part, timely adjudication of money disputes.
Yeah, and if we're talking about sort of legal health generally in the community, delay in family justice, for example, is going to lead to a whole host of other legal problems, right? So, and other difficulties as well.
Hi, my name is Mandavni Tami, and I'm an articling student at Parkdale Community Legal Services. I'm here in Toronto. I know there's a lot of people out of town. So I'm curious about something, and Justice Brown, you spoke on this a bit. So as we all know, the administrative state grew from the context of very specific socioeconomic and global context. We have the rise of the welfare state, and so we've developed these tribunals, and now we have these tribunals in a very different context. We have advanced neoliberal capitalism, and so I'm noticing that when we look at tribunals, and I'm thinking in particular about the landlord and tenant board, we have this need for efficiency because we don't want to have delays. And if we think about the landlord and tenant board here in Ontario, we have great delays. And I hear a lot of conversation about like, okay, so what can we do to address these delays? But I don't hear a lot about like an analysis or even any sort of critical discussion about how these delays coincide with these unique to our present context, circumstances that individuals are experiencing. So, we have the housing crisis. This is a context of neoliberal capitalism. We have, a greater gap between the rich and poor. We have all of these different things that folks are experiencing, the lack of good welfare rates. So welfare rates aren't rising. All of these are related to the neoliberal context. and exacerbate delays, I would think, because, for example, if there's a housing crisis, it's more likely, so if there's a housing crisis in a context where there's a lot of landlords seeking eviction so that they can make a greater buck out of their investments, and how that impacts tenants, there's going to be more likelihood for more tenants entering into that system. And so I'm wondering if you have thought about that when you have done your research, how that figures into your research. And I'm particularly interested in how, Noel, you mentioned that you're quite optimistic about tribunals, and I'm kind of thinking, and Justice Brown, you mentioned this a bit, like it seems like something from the past. It's not keeping up with the present in various ways, not just the delays, but now we're thinking about, okay, let's fix the delays, let's do more online stuff. What about all of the elderly, the seniors that aren't being able to access that mode of engagement with the tribunal system? Many elders aren't even able to learn about community legal services, for example. And same thing with I had a recent experience where there was an adjudicator who was very intent on getting through all of the review hearings and potentially some of the de novo hearings at the LTV. And as a result, I believe my client was put under a great amount of pressure that didn't, and the adjudicator did not account for what it would mean for my client, who's this Black woman, single mother, survivor of abuse, had a toddler with her, had been waiting for her matter to come to a conclusion up until 6 p.m. and had left the home at 8 a.m., was out of her unit, so didn't have food. So the adjudicator is not thinking about all of this. The adjudicator is thinking about, I want to get through all of these matters so there's no further delays.
Yeah, okay, so I think your question kind of revolves around maybe two main issues, which is kind of how when we think about delay, do we think about the kind of systemic issues that give rise to delay and the way that our society is going, the matters that gives rise to delays, right? And then also, considering the sort of disproportionate impact of certain solutions on certain populations, right? So going digital and things like that. So does someone want to address the digital part, and then maybe I'll address the systemic part, or does someone want to speak to that?
If I could make one comment, sort of at a higher level, I realize today we're talking about courts and tribunals. Courts and tribunals have defined jurisdictions. Those jurisdictions do reflect larger political decisions, historical and contemporary, about what these institutions should do. A mindset, I think a very unhealthy mindset, has emerged, particularly since the enactment of the Charter in 1982, where there's this notion that if you have a problem, you've got to go to the courts. The courts are the problem solvers, or perhaps their little kid sisters and brothers, the tribunals, although that mindset changed. But that should be changed. I mean, I think problem solvers for those sorts of higher things, particularly where you want to shift the political view as to what's important within a particular polity, lies with the people through the legislators. And people should ditch this mindset that you go to the courts to solve all problems and develop the skill set where you go to the political decision makers to try and change the yardsticks, change the boundaries of the system, change the perspective of the system. But law students, young lawyers and whatnot these days are becoming so myopic in terms of courts, tribunals. Go to the legislature. Oh, you don't have the skills to do it. Well, a lot of people came up with skills to try and influence public policy over the years, and that's neglected. So I think for some of these larger socioeconomic problems, you gotta forget about the courts and tribunals, look elsewhere.
And I think that goes to the more systemic thing as well, and we have to wrap this up. But I think this conference has really given us a great picture of how courts and tribunals are really just a small part of the picture, and more kind of systemic, wider legal needs, legal health, community legal health, that kind of thing. And I mean legal health in a kind of more, not just physical health, but mental health and a good life and things like that are way more broader than the courts and tribunals. And so of course we have to consider, especially historically marginalized populations in our processes and things like that, but it's really just a tiny part of the picture, which is why I goes back to the beginning where I said we're kind of old and dusty on this panel, because really courts and tribunals are just a very small part and a more traditional part, I would say, of communities' legal health overall picture. So we're going to wrap it up there, and we're going to move on to lunch. Thank you so much, everyone. Thanks.